And welcome to the Deal Doctor live stream, Monday 1 o'clock. And had a question come up on sub-agency. As you all know, we have people who are branch administrators and accounting folks who review files. And very often they'll come into my office and say, I'm looking at this file, and the agent has marked himself or herself as a sub-agent. And the question is, can they do that? And the answer is sometimes. First of all, let me talk about the listing agent. When you are a listing agent, you cannot be a sub-agent to yourself. So if you're filling out paperwork and you're the listing agent, you're the seller's agent, just the seller's agent, that's all. The issue becomes a little bit less clear if you are working on a 5-star listing. Let's pretend for a moment that I'm going to use Jeff Blahnik as an example. Jeff Blahnik has a listing, and you have a buyer. Can you be a sub-agent for Jeff Blahnik on his listing? Well, there are a couple of questions. First of all, did Jeff Blahnik offer a co-brokerage fee to a sub-agent? If the answer is no, then there would be no point in anyone being his sub-agent because he's not has not made an offer to pay them a co-brokerage fee. But using this example just for a moment, you're a 5-star agent, and Jeff is a 5-star agent. We're a designated agency company. Therefore, a sub-agent cannot be an agent for the seller because Jeff is the only one designated to be that seller's agent. So there's your answer as far as it regards within 5-star. Can you be a sub-agent to a 5-star listing agent? And the answer is no. Plain and simple. I had a long conversation with Gail Anderson on this issue. And Gail's position is this. Whenever, and this applies to all sub-agency, whenever you are a sub-agent, whenever any agent is a sub-agent, there is what they call imputed knowledge. As a sub-agent, you are assuming the responsibility that you know everything that listing agent knows about the property. You know where the boundary lines are, you know where the easements are, you know where the room square footage is, you know the depth of the swimming pool, and so on and so on and so on. And the reality is that buyer's agents working to sell a listing, whether it's a 5-star listing or a Coldwell Banker listing, typically are not going to know everything that the listing agent knows about that particular property. So this concept of imputed knowledge can be very dangerous when you sign yourself up as a sub-agent, let's say, for example, on a Coldwell Banker listing, and you don't have a relationship with a buyer. By signing yourself up as a sub-agent, you are saying essentially to that buyer that you know everything that Coldwell Banker agent knows about his or her own listing. Wow. Can you imagine how that's going to work if that should ever get to court? So what's the solution? If you're going to sell Jeff Blahnik's listing, you have two options. You can either be a buyer's agent, or you can be the seller's agent. The only way you can be the seller's agent, though, is to be added to the listing contract as a designated agent. The addendum regarding agency, I guess it's not an addendum in all markets anymore, but where it indicates you're a designated agent, if you're added to that, if Jeff were to add you in this particular example, if Jeff were to add you as a designated agent, then you could be a designated agent for that seller. But again, that also assumes that you know everything about that listing that the listing agent knows. So it's better to be a buyer's agent and designated as a buyer's agent if you're going to sell an in-house 5-star listing. It's frankly better to stay in that position as a buyer's agent if you're going to sell a Coldwell Banker listing. If you take the same example or similar example and you say, okay, here's Coldwell Banker and they've got a listing, and here's you and you've got a buyer. Can you be their sub-agent? Question mark. Can you be the sub-agent to a Coldwell Banker listing agent? The answer is yes, you can. If that, first of all, again, ask yourself the question or check the multiple listing and see whether or not they have added or offered a co-brokerage agreement commission to a sub-agent. If they have, well, then you're not going to get paid if you're a sub-agent. If you're a broker's agent, a buyer's agent, excuse me, or a transaction coordinator, and they have offered a co-brokerage offering to either a buyer's agent or a transaction coordinator, then you're going to get paid. But if they haven't offered sub-agency, then you're not going to get paid. Well, let's pretend for a moment that they have. Let's pretend that they've offered a percentage of the sales price. You can make it up, whatever it is. They've offered a percentage of the sales price to a sub-agent. Now the circumstances of you being a sub-agent are as follows. You have no relationship, no buyer's agency relationship with the buyer whatsoever. You are not watching out for the buyer's fiduciary responsibility, fiduciary well-being in any way, shape, or form. You are simply working for the seller and the seller's well-being. You owe the seller the same confidentiality and disclosure and all of those things that you would as if you were the listing agent. Ask yourself for a moment if that makes sense. You're out driving around looking at a bunch of houses with this person, even though you don't have a buyer's agency contract signed, even though they've said to you, we don't want you to be our buyer's agent, we're not going to tell you anything about us, but they decide to write an offer on a Coldwell Banker listing, which offers sub-agency. You choose sub-agency, and all of a sudden you are just as knowledgeable somehow as the listing agent on that Coldwell Banker offer or a Coldwell Banker listing. That's just not real. That's suggesting that you've actually been in the house, toured the house, measured the house, and so on. And if it comes back later that a buyer says, well, you represented something in that house to us incorrectly. Well, yeah, but I didn't know as much as the listing agent. Well, no, actually, this says that you did. The fact that you made yourself a sub-agent says that you did know everything that that listing agent knows about that particular house and property. So what's the solution? Well, if it were me, I would probably check off the box transaction coordinator if I were put in that situation. If the buyer said, I don't want you to represent me, I don't want you care if you are watching out for my interests or not, I'm not going to tell you anything, and all I want you to do is write up the offer, then I would probably say, how about I take the position as a transaction coordinator? It doesn't apply any agency responsibility on my part. It still pays me the co-brokerage fee if that's offered by the listing agent, whether it's 5-star or Coldwell Banker or any other brokerage company. So if you're put in that situation where a buyer doesn't want to make a commitment to you, doesn't want you watching out for their interests, and doesn't care about sharing information that will help them, all they want you to do is write up the offer and submit it to the listing agent, then frankly, I'd probably stay there. So I don't know if that answers everything on the sub-agency question. If you have questions, fire them up. My computer's sitting right here. Dom's going to forward them to me, and we'll see if we can answer them for you as best they can. Some of this dovetails with the whole issue of dual agency. Obviously, in the description that I gave you regarding the Jeff Blahnik listing, for example, whether you're a transaction coordinator or a buyer's agent, or you're added, how does that happen? Whether you're added as a designated agent on the listing or not, you're still going to, 5-Star, the broker, Greg Carlson, is still going to be a dual agent. And you still have to do the dual agent disclosure and acceptance by both parties prior to submitting the offer. Because the broker, 5-Star Real Estate, is still going to be a dual agent, with one representing the buyer as a buyer's agent or as a transaction coordinator, and the other one acting as the seller's agent. So I hope that clears. Sorry, the phone number, that was weird. Anyway, so any questions, please forward them on. Do we have a question?
Yeah, I'm getting
wow. It's kind of a tricky, it's a tricky situation to be in, and I know we've had this question on a lot of transactions. What if there, Penny up in Cadillac says, what if there is no compensation for a transaction coordinator? Good question. I mean, that kind of puts you in a situation where I probably would say to the buyer, listen, here's the deal. I'm not going to get paid if I write as a transaction coordinator. Can we establish a buyer's agency contract? If they're still unwilling to do that, then you have to understand that you're not their buyer's agent. Can you slide into the sub-agency position? I guess I would probably do that before, if they're offering a commission on this as a sub-agent, I would probably do that in order to get paid rather than go to the transaction coordinator and not get paid. But again, you have to understand, if you do that, there are some risks to that. And the risks are that that buyer has the right to believe, to assume that you know as much about that property as the listing agent. That's essentially what the law says about sub-agency, that sub-agent has imputed knowledge, has the same knowledge, that is, that the listing agent has. So there are some risks in doing that. Again, it's best to work as a buyer's agent in virtually all cases today. And I think that if you, as agents, recognize that sub-agency is not a realistic option and transaction coordinator is essentially representing no one, and very often isn't offered a co-brokerage fee, then you got to learn to persuade buyers to work with you as part of their team, as their representative, as their agent, to help them find the right house. And in doing so, you are there to protect their fiduciary interests. I hope that answers the question, but if there's no compensation under a transaction coordinator, listed under a transaction coordinator, you can either move to the subagent position understanding the risks, or you can try to get them to sign up as a buyer with you as a buyer's agent. I certainly wouldn't write an offer for free, frankly. Another question? Okay.
Oh, we do actually.
Penny asked, would the seller's disclosure and information on the multiple listing sheet cover you as an agent working as a sub-agent? Maybe. That's a very gray answer. I got it. But that's the truth. We don't know. Again, the legal precedent of imputed knowledge says that you know everything there is to know about the property as much as the listing agent knows. So if that listing agent knows information about the property which was not put on the seller's disclosure form or was not put on the multiple listing sheet, then you don't know as much as they do. Let's pretend for a moment that listing agent knows that there's a utility easement that runs 20 feet into the property from the road, that runs parallel to the road, 20 feet deep into the property. In addition to that, I get to draw. In addition to that, so we have the road here. We got 20 feet of easement for utility easement, and then over on this side, you've got an easement for a private drive, okay, that you can't, let's say here's a parcel. You can't build on either of those things, but I can assure you that they probably won't be on the listing card. They might be on a survey if you have a survey done, but those kind of details, the listing agent may know all about it, but until you write an offer, that information may not come forward, or until, worse yet, you do a survey, that information may not come forward. So going by the information on the seller's disclosure form and going by the information on the multiple listing may not be a complete knowledge of the property, and yet as a subagent you are held to the standard, the same standard as the listing agent is in terms of your knowledge of the property and disclosing that information to a buyer. Does that answer your question? If not, hit me again. Well, by the way, you'll be getting a notice pretty soon about downloading the app Kahoot for next week's Con Ed. I don't know when that's going to go out, but watch for it. It's important. Watch for it. I don't know if we're going to use their logo, but it's called Kahoot. And Kahoot is an app for your phone or tablet, laptop, whatever it is, that you're going to bring to Con Ed next week. And we're going to play a fun game. We're going to kind of change things up. We're really kind of excited about it. We've got this app is all set up. We finished the work on it. We're in the process of testing it and making sure all the everything's working properly. So in the coming days, you'll get a notice to download Kahoot onto your tablet, your phone, or onto your laptop that you're going to bring to Con Ed. It's going to be kind of a fun change up from what we've done in the past. And Penny, thank you. You're welcome. Penny, I hope it helps. What else we got today? What else can we talk about? You know, what I'd like from you, if I may ask, is I want to give you content here today and forward. I want to give you content that you need, that you want, that is helpful to you. So please, when you're viewing these, put something in the comment sections that says, here's what I'd like to know. I assure you that no matter what you put in that question, that request for information, you're not the only one who's wondering. I guarantee that. I get a lot of the same questions from agents, and what I'm trying to do for you all is to take the ones that we get the most often, at least at first, take the ones that we get the most often and get those to you, because I know that there are a bunch of people who are asking the same questions. I get their phone calls. Sometimes I get 2 or 3 phone calls in one day, which is exactly the same situation. Maybe not exactly the same details, but just the other day I got one about a protection period, and not 5 minutes later I got the same phone call from a different agent on a totally different property. So bear in mind, I'm trying to get you the information that you want and is going to be helpful to you, but you would help me a great deal if you could write down what that is. If there's something that we can get to you that's important, please. That's what we're here for. So, any other questions? No other questions. Okay. Okay. I think we probably spent enough on dual agency, but since we are at the tail end of a half hour, I will just caution again against dual agency, particularly in a situation where it is your own property. We actually have had situations where sellers are agents who are flipping a property or selling their own home, and they find a buyer. And they write down on the form, on the disclosure forms, and they get the disclosure, dual agency disclosure sign that they are a dual agent. Let's think about that for a moment. Can you think of any judge in the world who would believe that you own the property and you are going to watch out equally for the buyer's fiduciary well-being? That's just not real. And so I caution that when you're selling your own property or you are part of an LLC that is selling a property, part owner, whatever, you are always you should always remain in the position of seller's position. Never a dual agent, never a transaction coordinator, because you are watching out for your well-being first and foremost. And again, that's part of a long conversation that I had with Gail Anderson, our attorney. That's her position on it, and I think that's pretty well shared throughout the industry, that if you're involved in your own sale, you are always should always remain as a seller's agent and not pretend to be a dual agent or a transaction coordinator. If there are no other questions, I think I'm going to call it for the day. Please feel free to add questions if you watch this later. Put the questions in the comment section, and we have a question.
We do have a question.
Okay. One more. The letter of the law talked about the difference between confidential versus non-confidential information. What do you consider non-confidential information? They described it as anything that was known to the public or public knowledge. And that's probably a pretty good description of where you cross the line. I'll give you a story. One of my clients called me one day and said that he wanted to buy a property that was that he'd walked into on an open house, and he almost bought it from the builder directly, but he decided that he would call me instead. And I went, thank goodness. And so he called me, and so I'm thinking I've got a sale coming. And he had been looking for property that had, a little elbow room, a little, big backyard, not maybe some woods behind the house. He found the perfect house. He called me, and it was a Sunday afternoon. And in our conversation, he started to describe to me a house that was in an area that I had to ask him some questions. And I started to ask questions. I said, Dave, is that, help me understand exactly where that house is located. And he described that it was on the end of a cul-de-sac. It was, the house faced north, the backyard, or the house faced south, the backyard faced north. Yeah. I said, well, Dave, how do you feel about having a clover leaf to a highway in your backyard in about 5 years? And he said, what? I said, yeah. If you check the MDOT records, if you check the MDOT plans, 5 years from now, the cloverleaf to the M6 highway for Kalamazoo Avenue will be in your backyard. You'll hear semi-trucks. And he went, oh my gosh, I'm so glad I called you. Well, that was public information. For example, if I had been working for the seller, I probably wouldn't have been able to give him that information. But it was not confidential information, because the seller would have had, or buyer would have had access to that by going to the MDOT records or by going to the Gaines Township Hall. It was laid right out in front of them. If it's, another example is, a buyer sued my seller because there was a toxic waste dump that was adjacent to their property. I didn't know about it. The seller never told me about it. And the seller denied that they had any knowledge of it. Well, as we started to dig into it and things got uglier and uglier, we discovered that in fact the seller was in the newspaper photographed at the city council meetings, screaming at the city council about asking them what they were going to do about the toxic waste dump in the adjacent property. Well, that pretty much threw out his case. Again, it was public knowledge because it was published in the newspaper. And so when you, I guess, Penny, my question here is, you can consider non-confidential information to be anything that is a matter of public record, whether it's in the newspaper or it is posted at a municipality, like future zoning plans or developmental plans. All of those things are non-confidential because they're a matter of public record. That doesn't mean that they're common knowledge, that everybody knows about them. So I think that when you are representing a buyer, and in some cases a seller, you have to be aware of what information could get you into trouble in terms of if it's a material fact, if it is a material defect in the property, or you know that 5 years from now there's going to be a clover leaf on M6 in your backyard. I think that there's some responsibility to disclose it, but that's not necessarily exactly what the law says. So they take a position of, let the buyer beware, and that it's not confidential information because it is it's a matter of public record. So I don't know if that answers your question or not, but again, if not, type it in and we'll see what we can do. So thanks for joining. If you have additional questions, please write them into the comment section and we'll do our best to answer them for you. Have a great day.